Thank you, Charlie. Okay, it's good to see you guys here today. My goal today is going to be to help you to know the existence of these forms and what they do. If you have any questions, don't hesitate. Go ahead and raise your hand. We'll go through it. But what I find happens more often than not is people aren't familiar with the existence of the forms, and they're hard to locate. We did a real hard, at Legal Resources, really worked hard to try to rename all of the addenda and the amendments so that they say what they are. However, you still go look for an addendum, and they all start with addendum, and then you go, so you have to peel through about 20 to try to find the one you're looking for, and that can be hard. Still easier than using FAR/BAR, but nonetheless a little difficult. The other thing I want to point out is that even though some forms are called amendments, just because they're title amendment or addendum doesn't mean you can't use them, vice versa. So remember, an addendum is something that you're putting onto a contract at the time that it's being drafted, and an amendment is something that changes the contract after it's been executed and it's effective. So just because it's something is called an addendum or an amendment doesn't mean you can't use it one way or the other. So don't let that throw you off. If you're looking to do something after we go through the list today, you can use an amendment as an addendum. You can use an addendum as an amendment, okay? We also, I don't have it in this packet, but there's also a complete list of all the NABOR forms in wherever you use forms. So if you're using Transaction Desk or Form Simplicity or whatever you use, there's a list of all the forms. And sometimes that's an easier place to go to look for what you're trying to find. I like to encourage you to use these forms rather than drafting in the blank lines at the end of the sales contract, or even calling an attorney and asking the attorney to draft, because these forms, we've spent hours putting them together. I may not think that they're perfect, but I think they're pretty good, and they're usually better than what somebody throws together, put it in those blank lines of the contract. The one that I generally use when I'm explaining that is, I see more the past couple of years contingent on the sale of buyer's home than I have in the previous 35 years that I've been down here. So that, when I see realtors write that, it often says something like contingent on the sale of buyer's home. And what does that mean? What it really means is, what our addendum means, is contingent on the sale and the disbursement of proceeds from the sale of the buyer's home. Because I see arguments when realtors write contingent on sale of buyer's home about, now, is it sold because it went under contract? Therefore, the contingency is removed. That's not usually what the buyer intended, but now that's what the seller is arguing, because what happened? That deal didn't close. Now the seller wants the deposit. So it's a good example of why you should try to use one of these forms rather than make one up, get somebody to draft something, because believe me, and I want a little sympathy for that, Legal Resources Committee will argue for an hour about whether we use the word the or the word the. Okay, so I can tell you, we have about 10 lawyers on the committee and about 12 brokers. So between all the lawyers being lawyers and the brokers want to argue about how things work out, sometimes it takes forever to get something done. But I think the forms are pretty good. So I'm going to go through all of them. I haven't divided them up into particular segments. I pulled them off of Form Simplicity just exactly the way they appear on there. They're not in any particular order there. So if you're looking for addendum, sometimes you have to go down to the bottom of the list of forms. A good example for that is the new condominium addendum. That's way down at the bottom. It's not alphabetical where it should be up at the top, because when that became available, it went to the form vendors. They shove it in where they can, and that's the bottom of the list, okay? All right, so, and by the way, if anybody that's ever wondering why it takes so long for these forms to show up in Form Simplicity or Transaction Desk or whatever, there's about 8 vendors that have these forms. I think Caldwell Banker has their own that they put their label on. Maybe some other brokers have that. We have Zip Forms, Transaction Desk, Form Simplicity. They all have to get loaded. When we do the revisions to contract forms generically, we send them out, and once all the vendors are ready to go, that's when they go live, okay? During the recent events with respect to buyer brokerage agreements and all the new things that we're having to deal with, we shoved those out right away, and they just were available as soon as they were. They were available on NABOR's website as soon as we completed the form. But as to each vendor, it's just whenever each vendor got the forms online. And some of those vendors weren't too happy with us because we were shoving out a lot of new forms, and they had to keep going back. So that gives you some idea. Last thing I'll say before we get into these, I know that you guys are the professionals here. You have, I'm sure, forms books that you've put together. If I've got a condo, here's all the forms I want to use. If I've got a residential, here's what I've got. It's a vacant lot, here's what I'm going to use. So you've got forms packets. If you haven't done it, and I suspect you have, but if your compatriots haven't done it, update to the 2025 January 1 forms, because those are all the currents. They have all the updated legal requirements. The condominium addendum has all of the new things with MERS and SIRS and everything else we have to have. So please, every time we get new forms, go back and update your form packets that you put together, okay? All right, so let's go through. Let's start with addendum to sales contract, seller's right to make a backup contract primary. And this, again, these are coming out of Form Simplicity order. They're there. This form right here is used if you have the contingency in which the backup contract has been executed. This gives the seller a right to make a backup contract primary. And how this works is that the seller, this right here, has the right to continue to market and show property and solicit into bona fide backup contract with a third party after the backup contract is effective. So now the seller has got a backup contract that the seller is going to accept because there's a contingency in this one. The seller notifies the buyer, and if the buyer elects to proceed with the purchase, then the buyer notifies the seller of such election, delivers an additional escrow deposit not later than 3 days after receipt of notification of the backup contract, and the buyer shall be deemed to have waived the contingency. So whatever that contingency is, the buyer's waiving it, turning this contract into a contract. So if you've got a financing contingency, whatever else you've got, this is now turning the backup contract into, turns the primary contract into an uncontingent contract because the seller has obtained a backup contract. Everybody familiar with that? Okay, let's see if I can get this to move to the next form. Okay, addendum to lease. Anybody here do leases? You do? Okay. This is the addendum to lease for lead-based paint. So this is the form, as you know, under federal law, you've got to make disclosures for pre-1978 property. So if it was built prior to 78, and this is a form that will meet that requirement. I'll just go through it briefly. This section right here is that the landlord says whether the landlord knows or doesn't know about lead-based paint, that the landlord has provided the tenant with all available records concerning lead-based paint. And then down here is the tenant acknowledges that the tenant has received copies of all of this. The tenant has received the pamphlet, Protect Your Family from Lead in Your Home, and that is available with your forms. I know it's in Form Simplicity. I believe it's in the other forms as well. And the tenant receives this attachment or comparable disclosures at any time after date of the lease agreement. Tenant has 3 days, excluding those Saturdays, Sundays, legal holidays, to terminate the lease. So you want to give the tenant this before the tenant signs. That's only for pre-1978 properties because lead-based paint was outlawed and they weren't putting it in anything after that. Okay? All right. This is one that I hope you don't use. Anytime we have something that looks like that, it scares me to death because that's where you guys get creative. And then we only find out how good your creativity was when a problem arises, okay? And I say this all the time, and it's scary for me to say it, 99% of the things that you guys screw up work out okay. Y'all agree with me on that? And that's why a lot of your compatriots continue to screw up because they hardly ever have a problem with mistakes. Okay, but what happens when you do have a mistake? Especially in our market, right? We're talking about properties that are 5 million, 10, properties that we're closing today, single-family residences. I used to take great pride in 10 years ago that I was doing big deals with developers for that much money. 10 years later, we're doing single-family homes for that much money. Well, with that comes liability. So if you've got a mistake, you not only have a legal liability and you've got E&O coverage, but go take a look at those E&O policies. Some of them only go up to $1 million, maybe $2 million. And your liability may be substantially more than that. Certainly there's a deductible, a copay, and I think most brokers require their agents to pay that part. And you've got an ethics issue, so be careful with all of that. But anytime you get tempted to put this in, I'll just tell you, I don't think this form should even exist, but it does. Okay, next form we've got is the addendum to listing contract, limited brokerage services. So we have a new world, right, on what we're doing. This also is a form that we've had for a long time. I rarely see it used, but it allows the broker taking the listing to limit the services that are going to be provided to the owner of the property. So we start with the seller and the broker's name. And always remember that all of these forms require the broker's name, not your name. I know I'm preaching to the choir because you guys are the cream of the crop. But, again, everything that we talk about here, if you go back home and talk to other agents in your office about it that might need education, it would be a good idea. So we've got, what are we going to do? We're going to limit the services provided by the broker. And these are the limitations of things that you can be limited to. Pricing assistance. So some people might say, I just want you to help me price my property. So this is what we're going to do. Pricing assistance. Advertising the property. So this gives the broker the right to advertise in media deemed appropriate by the broker. Post signage, etc., etc. Provide signage. They're retaining you to provide signage. Put the property in MLS. Reciprocal broker websites. Information on the property in the MLS may also be displayed on websites of other participating brokers. To hold open houses. To show the property. To put a lockbox on the property. To present offers. Contract negotiations, and for transaction assistance, and for other. And I'm not sure what to put in other. Anybody here think of other services that somebody might want you to just carve out? Okay, this does not change the statutory presumption that you're a transaction broker. Okay, so if you're going to be a single agent in some fashion, you still got to do the disclosure for that. If you're still a transaction broker, just limiting the services to be provided. So this is a good form to think about. Whenever you're talking to somebody and they don't want you to do all of the normal things, you're talking to them, well, I really just want, maybe you can put a sign in the yard or maybe put it in MLS, nothing more. And this helps keep you off the hook for somebody claiming that you didn't act as a professional and do what you're supposed to do. And therefore, when things don't go well, filing an ethics complaint against you because you've got the limited services agreement. Everybody good with that?
Bill, there's no compensation on that form, right?
No, no. You still are going to have a.
So that's just
yeah. So this would limit what. Remember, this is addendum to listing contract. So this is listing contract. Now we're limiting the services that are going to be provided by the listing brokerage. Okay. Everybody good with that? Thank you for asking that. Okay, we're moving on now. Addendum to listing contract, short sale. Are we doing those anymore? Okay. I actually had a mortgage foreclosure. And I had a client buy one at a condominium lien foreclosure and another client buy a property at a condominium lien foreclosure. So I don't understand what's going on with that because it looks like there's lots of equity and everything, but it does happen. So this will be a addendum to listing contract when you do get into that situation. I won't spend a lot of time on it because I don't think we're going to be using it as much in the near future. But this provides what a short sale is and what the responsibilities of the parties are in connection with the short sale. And one of the most important is number 3, the seller acknowledges seller will not receive any net sale proceeds at closing. What this document does is it really sets the table for the seller to cooperate even though the seller is taking a haircut and not getting any money. And you want to have that because otherwise the seller's not going to agree to anything. And when we had the short sale heyday, we got a lot of sellers that decided, gee, I need to get something. I heard some people are getting paid move out expenses. I'm not going to close unless I get this. And then they go ahead and sue me. I have no money anyway. So I mean, what the heck? This is a good document when you're doing a short sale. Okay? All right. Another one of my favorite forms. We'll just skip through that one. Say addendum to sales contract review by. We do see this one. Anybody use this form? You have folks and they say, well, gee, I want to have my lawyer. Of course, that always makes me nervous. I want to have my Chicago lawyer look at this. You know, we always really have a lot of fun when the out-of-state lawyers want to start getting involved. But what this does is it gives the buyer X number of days after the effective date to have the contract reviewed by the buyer's accountant, attorney, or other advisor, and the buyer can terminate the contract during that time frame. So that there's no extra time. So if you put a number of days here and everybody agrees to it, the end of that last day is the deadline for the buyer to terminate the contract. Now, does the buyer have to get a letter from the attorney saying the contract's horrible, you need to cancel? No, I don't think so. What this just says is there's time for review. So what does this really do? Makes it an option contract because now the buyer has whatever number of days you have here to, if they want to, talk to an accountant, talk to an attorney, talk to their mother-in-law, whoever it might be, and then during that time frame to terminate. The important part for you, if you want to do that, and I have had a couple of these this past year and a half, where my clients wanted me to review the contract before they signed it. And if you're in that situation, well, this is an option to say, well, we can't reach your lawyer's out fishing today or playing golf or having his kidneys taken out or whatever it is. Now you could say, but we can do this addendum to the contract and it'll give you X number of days to talk to your lawyer and decide if you're going to stick with the deal. That's not as good as having this condition not in there and the lawyer looked at it and said it's okay and you're signed, but at least it can get you to a signed contract, potentially. Yes, ma'am?
So if you have the buyer and the seller doesn't want to let you out of it and they exercise this, what can the seller's agent request to make you not be able to?
Well, what I find is the biggest problem here is that, and I haven't had it in my practice, but my fear for this form, it's not the form, it's the operation. Okay, and that's what goes wrong with these things, is that the buyer has, let's say, 3 days to get their lawyer to look at this and understand that if that deadline falls on Sunday or Saturday or a legal holiday, it'll extend to the next day that's not one of those days. And it extends, remember, till 11:59 p.m., not 5 p.m. Had that one. My fear here is that the buyer goes and talks to the lawyer on the 3rd day, and then that's kind of the end of that. And then on the 4th day or 5th day, they have talked to the lawyer and they've decided it's not a good deal. And it's really a financial thing. They've had buyer's remorse, whatever it is. And they now want to get out of the deal, but the 3 days have expired. Not the 3 days for them to talk to the lawyer, but it's the same deadline for them to terminate the contract. Now, I don't want you guys to get contracts terminated, but they always come back to blame you for anything that goes wrong. So you really, if you use this, and I think this is a great way, if you couldn't get your lawyer today, and we're not going to go through all that, and we put in a few days, and in this market probably works better than it did when the market was on fire. Here you go. You can go talk to your lawyer. You'll have time to talk to your lawyer. You can do it. You're not being rushed. And that's sometimes a pretty good thing as well, because I find in transactions that when people feel they've been pushed, and I'll hear that, I don't hear it very often. I'm happy to say that. But when I do hear, oh, the realtor's pushing me, the realtor is only interested in getting a commission, the realtor, this is a great way that you're not pushing, you're giving them time to talk to their lawyer.
Can the seller request documentation? You know how if you don't get a mortgage?
No, it doesn't say that the lawyer has to approve it. It doesn't say the accountant has to give you a disapproval. It doesn't say anything like that. It just says they have time to consult, and that during that time they can terminate for any reason, okay? So they don't even have to consult. So this I do see some people over the course of my practice that have used this form or something like it just to buy some time to think it over, okay? Now, we do have other options for that these days. We have the as-is right to inspect contract, but a long time ago, I saw occasionally people would use this when we didn't have a right to inspect as-is contract where they basically have an option anyway. They would use this to buy some time to decide whether they really wanted to buy or not, because they could use this the same as they use that other contract form to make 5 offers on 5 properties, sign them all, have the seller sign all of them, and then however many days they've got to make a decision on whether or not they're going to close on any of them, right? I haven't seen this form used that way, but it could be, okay? Most of the time I've seen this legitimately because I'm the lawyer. The reason I see it is because I'm the lawyer that the person wants to come talk to, and this is part of the contract, and they don't come to see me anymore. They send me the contract form and ask me to review it, and 99% of the time I go, everything looks great. So that's something to look at. Okay, everybody's good with this form? We have the same form for sellers, and there it is. Okay, same questions, right? Seller have to have a letter? No. Seller has X number of days to terminate the transaction and can talk to all these professionals and anybody else. Okay.
Seller could use it if they think they're getting multiple offers.
Sure. But again, I haven't seen that in my practice. I haven't seen this form used for that purpose. I've seen the as-is right to inspect contract for buyers use that for that purpose. We're all familiar with that. But this one I just haven't seen. I've seen this occasionally used legitimately when somebody wants to think it over, not because they're making multiple offers. They're just not 100% committed to whatever the deal is. And I've seen it used more often when they legitimately want to talk to their attorney. I don't think I've ever seen one where they really want to talk to their accountant. Okay. All right. Then this is the form I used as an example at the beginning. Addendum to the sales contract, sale of buyer's existing property. And remember, we're using the term addendum, so we're using this at the time we're writing the offer, the contract. So the obligations under the contract are contingent, and this is the important language, upon closing and disbursement on the sale of buyer's real property located at, and this is the other part, which is presently under contract. Okay? That was verbiage that was put in by Legal Resources Committee because they didn't want to see this form being used when the buyer was just going to go try to sell something. They wanted the seller to know that there was a contract pending for the sale of the buyer's property, so that it wasn't just a, waiting to see if they could sell it. So this is important because if you use this form and the buyer's property is not under contract, then you open up the door to all kinds of claims like fraud, that you didn't professionally act, and that the buyer then doesn't get out of the deal because the buyer misrepresented that the buyer's property was under contract. I don't know how all those play out because I've never had to deal with them and I've never researched them, but they all worry me from your perspective because they all create potential liability for a realtor. Okay?
Surely that destination would confirm that it's under a contract before, right?
Yes.
If I wrote that and say, oh, it might
Yes.
be under a contract.
Now, I do see this more often used, and I've seen it used in the past 2 years a lot more than I saw in the past 30. So this is, and up north, this is more common. So down here, not so much because we're a second home, the market's different. But right here, though, if such closing disbursement does not occur on or before blank date, either seller or buyer can terminate the contract. But buyer has the right to waive this, so the seller's right to terminate shall cease if prior to the seller's right to exercising the seller received notice, buyer is satisfied or waived the contingency. So all those protects the buyer, and I did have that happen in the past couple of years. The buyer had this contingency and then decided they wanted the house bad enough that when their deal fell apart on the other home, they were willing to sell stock in order to buy the house. So they waived this. Now, they were still hoping that they could sell their house before they had to close on the house that they were buying down here, but it wasn't a contingency anymore. Yes?
Is there a form to waive, in other words, a form to waive financial, or waive this, or is it just?
No. But it's pretty simple. The buyer would just sign a document that says, we hereby waive the contingency on sale of the buyer's property. And that would work. Yes, ma'am?
What if somebody crosses out, which is presently under contract?
Well, that's what's done. Okay. Now, as you know, realtors aren't allowed to cross anything out. Or maybe you didn't know that, but now you know it. Okay, so y'all don't cross that out. But if your customer crosses it out, that's not something that can't be done. And I like this form. So if somebody were going to ask me to put a contingency together, I would take this form, and if it wasn't under contract already, I would cross that out and just go with it. I think I do that for two reasons. One, I like our forms. I think they do a pretty good job. And number two, don't you think everybody feels more comfortable with a pre-printed form than they do with something that the lawyer drafts up? And I always giggle because there are some attorneys that I do closings with, and they have taken some of these forms and they have taken them word for word and put them on a separate sheet of paper so it doesn't look like a neighbor form. And then they say, here's the form I drafted for you. And I laugh because it's not this form per se, but it's another form. And if you compare them word for word, the same, which actually, you see this down here? I think there's a copyright notice down here. So, but I think that's cute. But the forms are pretty good, and this one works pretty well. Okay? And this says, the seller shall not be able to close on sale of the property fewer than 15 days after the date buyer gives notice to seller of satisfaction or waiver of the contingency. And that's in there because a lot of those contracts that are using this, they say closing to be, they might put in as soon as possible after buyer closes on sale of their home or something like that. That's when that goes in the blank lines above the signature lines. So be careful whenever you're filling that in. But that would allow the seller to have 15 days so the seller can get their stuff together, move out. I had a few deals a couple of years ago where the sellers actually wanted a post-closing occupancy agreement. Very elderly, very frail, did not want to have to move out until they were sure that they were closed. And I thought that was one of the few times that I'm okay with a post-occupancy or pre-occupancy agreement. Any other questions about this one? Okay. All right. Addendum sales contract survey inspection. Now, we know that the sales contract has a provision in it that allows the buyer to obtain a survey and to tell the seller about any problems that the survey shows up to 5 days before closing. Okay? But here, we had another provision that if the buyer's really concerned, wants to do that at a different time, the buyer shall have 15 days after the effective date to obtain a survey at buyer's expense to determine the property is the same property visually inspected by the buyer. The survey reveals property is not the same that was visually inspected. The buyer may terminate. Where might that be important? Not necessarily here so much, maybe out in Golden Gate in your market that might be more important. I had a deal, I had a deal years ago where one of my clients bought a property, then went up north and came back the next year and came in to see me and said, they're building a house on my lot. And I said, well, that's good, you get a free house. And turned out that the realtor had showed my client a property from a plat, and the area had been replatted. And my client thought that my client had bought, property A, and it really had bought property B on the replat. And that was kind of a mess, needless to say, but he didn't get a free house. But a survey in that case would have shown, because the property that he was buying was an end of the canal lot, and he thought he was buying a side of the canal lot. Okay, so I don't see that this is going to be a real help on Marco, but it could be in some other parts. Yeah.
Recommend buyers having a survey?
I always recommend buyers have a survey for two reasons. Even though we can write title policy without a survey exception, if we get an affidavit from the seller and a survey to the seller that says, here's what it looks like, and the seller says in the affidavit, I haven't made any changes to the property since the date of that survey, and that survey is accurate. Okay, but I don't like that because I can't sue that surveyor. I still got a title policy for my client, sometimes my sellers aren't sure if anything was done. I had one just the other day said, I can't sign that affidavit because I put a new seawall in. Well, would the typical seller think that's change to the property? I don't know, okay? I did have one where my client was too cheap to pay for a survey. We did not get a survey affidavit, and after closing, he had called me and he said, I have a problem because the dock is in the wrong location and the city is making me tear it out and move it. And it cost him, at that time, which was years ago, $65,000 because he wanted to save $800 from a survey. Okay? So I tell people get a survey, and the third reason I tell them that is because I don't want them to sue me for telling them they didn't need a survey. Just like I don't want them to sue you for telling them they don't need a mold inspection, they don't need a radon inspection, they don't need an appliance inspection, they don't need a building inspection of any kind because it's brand new or whatever, okay? You tell them they need everything because they do. Only if you tell them they don't, you become the guarantor and the warrantor that everything's fine, right? Okay. Any questions on this one? All right, then we've got an appraisal contingency. So I've seen this, but I see people writing that into the contract. So let's use the form here, folks. The contract is contingent for a contingency period of 15 days if left blank. From the effective date upon buyer or buyer's creditor or lender obtaining an appraisal of the property by a residential or general appraiser certified under Chapter 475 Florida statutes, which, as you know, is the real estate in Florida, showing a value of at least whatever it is, and it's the purchase price if left blank. If the appraisal states the property is not appraised at the value at least equal to that, the buyer could terminate the contract by providing written notice to the seller with a complete copy of the appraisal unless the seller, not later than 5 days following receipt of the notice and the appraisal, notifies the buyer the purchase price will be reduced to the appraised value. I see that, I've seen this used, actually I rarely see this used, I see realtors writing in the blank lines, contingent on appraisal, satisfactory to buyer or something like that. So here's a great thing that gets everybody on board is have to appraise at the purchase price, or is the buyer okay if it appraises at something less? And when we're in a red hot market, we know the appraisals are coming in low, right? When the market's falling, I don't know what the appraisals are doing. I know the market's not necessarily red hot right now, but I think this works good. And in my experience, buyers didn't necessarily have to have the property appraised at the purchase price, but they wanted it to be close. And if that's the case, then what do we put here? What that number is the buyer's okay with. It's a $1 million property. If it appraises at $970, I'm okay with that. I mean, I don't know what that number would be, but that's a good discussion to have with the buyer. And by the way, as I always say, everything that I recommend or suggest or discuss is always subject to your broker's approval. So just because I say it's a good idea doesn't necessarily mean that it is. So always check with them. But I like this form because I see this on cash deals. People with mortgage financing are usually somewhat comfortable. But again, even with mortgage financing, look what we've got. You know how those come in. They don't order the appraisal until they've got something that makes it looks like the loan's going to work. We never know when that's going to happen. Is your buyer going to get pushed by the seller to waive the financing contingency? Where are we going with that? Well, that might be a time when your buyer wants to get an appraisal on their own just to make sure that everything looks good and they're more comfortable that the property is going to qualify for the loan. Again, that's up to your buyer. We're dealing with millions of dollars of property and appraisals that cost what, $650, $750? So, but people are cheap, so they will not pay $750 because they don't want to. But here's a form if they're going to and make the contract contingent on that. I think it's a good form. Okay, mostly on cash deals. Okay, and down at the bottom, time is of the essence as to this addendum, because remember, most of our neighbor stuff, time is not of the essence, and it is in FAR bar. Okay. Addendum of sales contract, backup contract. So this is when you've got a property and it's under contract and your buyer says, you know, there isn't anything else. This is the one I really want. Let's do a backup contract. So it makes it clear that the contract is subject to a previously executed and existing sales contract for sale and purchase between seller and a third party, and then we put the third party's name in, and it's contingent upon termination of the primary contract. So this says it's a backup contract contingent on termination of the primary contract. So if the primary contract is terminated, the seller shall promptly give written notice of the termination to the buyer. So maybe the primary contract's got a contingency in it for financing. Maybe it's got something else. It ends up terminating. The seller then promptly notifies the buyer, and then this contingency is satisfied, and this becomes a primary contract. Okay, so the termination of the primary contract for the contingency not being met, and notice to the buyer under this addendum then turns this contract into the primary contract, right? Because the primary contract is gone. Okay. If the buyer has not received this notice by 5 p.m. on whatever the date is, then the buyer can terminate the backup contract by giving the notice to seller. If no date is inserted, buyer can terminate the backup contract anytime prior to receipt of the prior contract termination notice. Does everybody understand that one? Everybody good with that? Okay. Either y'all are going to sleep or you're actually understanding what I'm saying. That's good. Either's fine. Either's fine. Addendum of sales contract, cooperative. Now we talk about that when I train on the contract. And this is the addendum that you must attach to the contract for two reasons. One, a co-op is a corporation in which your buyer is buying a share of stock, and that share of stock gives the buyer the right to occupy a portion of the property. That clearly isn't buying dirt, so we got to do something different. Good news is, y'all don't have to have a securities license to sell that. The other reason we have to do this is because with all the new requirements for the milestone inspections and the structural integrity reserve studies, there's a lot of disclosure language that has to be provided to a buyer of a co-op, just like of a condominium. And this form accomplishes both of those requirements, okay? So I want to go through it briefly with you. So we talk about who the parties are in the property, and then we get down to the rights and title, interest being sold, are the cooperative parcel evidenced by and described in the cooperative document. So we're starting to move this from a real estate purchase into a cooperative purchase. All references in paragraph 4 of the sales contract for mortgage means a security agreement. So paragraph 2, remember, this is not real estate per se that we're dealing with. So if there's going to be financing, it's financed with a UCC. We still record that like a mortgage, but it's not really a mortgage, although we kind of generically talk about a mortgage when we have a lien against something. It's going to be a UCC, Uniform Commercial Code, because it's a sale transaction of something other than real estate. So that's how we're going to finance it. So we changed the sales contract. Instead of talking about mortgage, we're now talking about UCC financing. Number 3, the seller represents and warrants to any ground lease. And then we talk about the ground leases. There are a lot of co-ops in Collier County that have a ground lease. And this talks about whether or not the property is on a ground lease or not a ground lease, and whether the cooperative property is not wholly owned by the association, and whether the buyer has an obligation to pay a proportion or no obligation to pay any part of the rent for a ground lease. And it might even be a ground lease of the recreational amenities, okay? So, and it says down at the bottom, if the remaining term on any ground lease is fewer than 40 years of the effective date, this contract may be terminated by the buyer giving notice of said termination within the examination period in Standard B. So Standard B, the sales contract, the examination period is still that inspection period, okay? Oh, excuse me, 30 days for title. So you've got a 30-day time frame to look at this. This is important to understand that you've got some of these on land leases. We've talked on legal resources. There are some that are at 40 or getting 40 or less than 40 right now in the county. And there's been some discussion about changing that 40 to 35 because there's so many of them that are getting to a point that they're there. So that's something important for you to be aware of. If you're dealing with a co-op, you need to be sure that your folks, whoever's doing the closing, is going to examine that ground lease, because your buyer may be very unhappy to find out that your buyer is buying a property that's on a ground lease that's got 25 years left. And the buyer's thinking, well, I may be owning this for 10 or 15 years, and then I'm going to sell it. And the lease has got 10 years left, and I'll be selling 10-year worth of whatever somebody buys, okay? So that's a big deal. Some people may or may not look at that, but it's on you to help make sure whoever does the closing for the buyer, whoever's issuing the title, and I just suggest even if the buyer's attorney is not issuing title, you make sure that that person is checking the extent of any ground lease and how long it has left to run. Yes?
I live in Marco West, and I think he have the land condo in the south, and that happened to me in the back out because their financial advisor break out as well.
Well, there's a good example. And they do exist, and off island there are a lot more co-ops than I realized. I thought Enchanting Shores and was about it, but no. They're pretty tony too. There's some even up near Pelican Bay, not necessarily in Pelican Bay, but there's some pretty nice properties that are co-ops. So it's not just low end stuff. It's it runs the gamut of finances. But that's a big deal to me. I always think about that when I look at some of these timeshares people buy. They originally are 99-year timeshare, and then over some period of time, they're now 29-year timeshare and a 9-year timeshare.
For the recreational things like a golf course that, place looks over this beautiful golf course.
Well, that would depend on whether or not this particular co-op is leasing the golf course and its amenity for that co-op. On a golf course, well, there's never a guarantee the golf course is going to stay there. I mean, the county has some new rules on how to redevelop golf courses, and they're just doing that one up there that on the corner of 951 and Golden Gate, where they're developing that into a whole project now. So, I mean, most of the golf course communities, the golf course is owned by a homeowner or operated by a separate association. Some you have to be a member of the golf course, some you don't. Lately, the golf courses are completely separate. So it just depends on the community, and that's something that if that's an issue for your buyer, that's a good thing, and that's not a contract contingency. But if you're worried about the type of membership for the golf course, then that would be something. And we don't have an addendum or an amendment for that, and that would be one where I think you really need to talk to an attorney to draft something, because not because I think you guys are dumb, but just whenever you start drafting, that's when things go wrong. And that's a kind of a thing that would be unusual and would be something that we just don't have a pre-printed form because we don't bump into that very often. Okay. All right, so we go to page 2. We talk about title evidence, and again, remember that, and that's an important thing to remember in the sales contract, is the buyer has 30 days from the effective date to raise any title objections. And that's another important thing. You need to, whoever you get the closing to for a buyer, make sure they look at title right away, because there's only that 30-day time limit. If you go past that, then at some point you waived any claims to title issues. So we're going to use all our title stuff. It has to be accompanied. The title information and all necessary documents have to be provided to the buyer by the seller. So that's under paragraph 4. Paragraph 5 is seller will provide buyer with a UCC encumbrance search. So remember what we said, that this property co-op is mortgaged with a UCC document, which is for personal property, and the seller is going to provide a UCC encumbrance search, which means sellers, normally that would be a buyer's responsibility, but the seller is going to do that as we think that's part of the title documents that the seller needs to provide. Okay, cooperative statutory resale disclosure. So paragraph 6, 7, 6 is that if you recall the condos, say you get the declaration, bylaws, articles, all that, and we have to have this language. Co-op has similar documents. They all have to be provided to the buyer, and the buyer has the same period of time, 3 days, to terminate the contract from the day the buyer gets all those co-op documents, okay? So if you have any questions on any of that, get your closing attorney to help you walk through that, because the contract is not a contract that we're definitely going to have people bound to until 3 days go after all of that happens, okay? Now, Section 7 is the MERS and the SIRS stuff. So just as in condominiums, if they're 3 stories or more, they have to have a milestone inspection study at 30 years, possibly earlier if the local building official orders it. And all residential condominiums that are at least 3 stories tall have to have a structural integrity reserve study at least after 10 years and then every 10 years thereafter. So you have to have these structural integrity reserve studies even though you haven't reached a point where you need a milestone inspection study for condos. Same rule applies to co-ops. Okay, so when the legislature passed those statutes, it said, you know, it doesn't make any sense to carve co-ops out. Let's throw them in with it because co-ops and condos, you reach the same result. People move into them. They're buildings. People want to live in them. So we've got these provisions that is or is not required to have a milestone inspection study. Same rule, 30 years for co-op, 3 stories or more. Okay, whether it is or is not. And then number 2, is or is not required to have a structural integrity reserve study and has or has not completed one. And then C, is or is not required to have a turnover inspection. Anything where they've turned over control of the association to the owners on or after July 1st, 2023, they have to do the developer has to do a special turnover report. So we'll see more and more of that going forward. Anything prior to July 1st, 23 does not have to have that. So this is where your seller needs to fill this in because you won't necessarily know that. The co-op and condos are both required to provide the summary of the milestone inspection report and the SIRS to the unit owners within 45 days after they're completed. Okay, and they're all completed by now because the deadline was December 31. Well, they're not all completed, but they're supposed to be completed December 31, 2024. Okay, so for most of these co-ops and condos that are 3 stories tall, these are going to all be, yeah, that was done, yeah, we have it, and you know, it's available. Yes? Well, there's 2 risks. Just while we're on that, is there any risk to if the milestone hasn't been completed? Well, certainly the risk is we don't know what the structural integrity of the building is or buildings, so we don't have a good idea of what the structural integrity reserve study will say as to what the owners are going to have to pay to fix the building and take care of it, and that's the risk. The risk, at least when the milestone is done and the structural integrity reserve study is completed, is that we have a good grip on how much it's going to cost to be an owner in that building because we know that by statute, owners can no longer waive or reduce funding for reserves for structural items. And that list of structural items that they can't waive or reduce funding for extends beyond things that you might think are really structural, okay? So that is going to say if you've got a just think this through. If we've got a 35-year-old building and we've got a milestone inspection and a structural integrity reserve study, and those owners have been waiving reserves for 35 years, and now they can no longer waive the reserves, but they have to fully fund, and some of these items have to be done right away, and some of them maybe in 5 years. That could be some substantial assessments. And that's where there's liability for you guys as realtors because you need to help your folks understand that. They're buying an older condominium on the beach because it's on the beach with a beautiful view. They might be buying it with a large assessment coming along because of the fact that they can no longer waive these, okay? And purportedly, we find that out not only by looking at it and saying it's old, it's on the beach, you're going to have to be doing some work on it, but because we're going to have these studies and we know what the reserve study says of how much they're going to have to set aside. Okay, and for these items, they can still do the blended funding for them, so they don't have to have a special line item for each one. But nonetheless, I think some of these older condos are going to have some substantially increased assessments in the next few years. I think there is, but I can't remember it off the top of my head today. Okay? But as far as our presentation today, the concern is this is a big deal. And if your guy or gal is looking at a property and it's older and it's beautiful, it's got that great view, and looking at a much newer one, and the cost of ownership is huge on the one with the great view, that cost of ownership has got to be something that's discussed, in my opinion, as to whether or not the view is worth the cost of ownership, because we're all looking at cost-benefit analysis in these things, and there's something more than just price per square foot of air-conditioned space. Okay, so I think this is going to be where there's going to be claims made ethically that you didn't disclose, you concealed, you did these things, and there's going to be lawsuits when people say, well, gee, now I've got a $40,000 a year assessment, and nobody warned me about that kind of thing. Because you just look at all the disclosure we have. We have this, and in homeowner association, we have the other disclosure. We have to let them know what it costs to be a member of that homeowner association, right? So legislature is really big on what's it cost to own a piece of property in this development, and this is a big part of that. And there's been some doomsday articles written about how people are going to be priced out of just living in these buildings because they can't afford the assessments. And I can see that coming because I have represented a lot of condos over the years, and in some of those condos, especially some nicer ones, there's often a conflict between the folks that bought 20 years ago and didn't have to have a lot of money, and the folks that just bought. And the folks that just bought who have a lot of money want to upgrade everything and pay for everything, and the other folks can't necessarily afford all that stuff. And that's just for upgrades, not structural integrity. Okay, so then we go down to the bottom of this, and we're going to kind of go pretty quickly through the condo form because it's almost the same. And this all language that has to be in here, and 553-899 is the Florida statute that talks about the milestone inspections. And it says here that the buyer has been provided a current copy of the inspector prepared summary of the milestone inspection, copy of the turnover inspection report if it exists, and a copy of the most recent structural integrity reserve studies at least 3 days before contract. Or the other paragraph is that the buyer has 3 days after getting all that stuff to terminate the contract. It says void the contract, terminate the contract, get back the deposit. So this is directly out of the statute. It really should be like a or and check the box. And I think we're updated the condo form. We didn't update the co-op form yet. But this came right out of the statute, so the committee was really concerned with being even that creative of putting an or check the box. So plugged in exactly what the statute says, and this is what the statute says. So you either give this stuff to the buyer 3 days before the effective date of the contract, or the buyer has 3 days after the effective date to terminate, both for, and remember this will be the same for the condominium addendum, which you have to attach. No longer are all these warnings and disclosure language in the contract form. You have to attach the addendum. So they got the milestone and the SIRS here, and all the governing documents and rules for the co-op or in the condo form, and we'll skip through that when we get there, for the condominium association. 3 days from the day the buyer gets that to terminate the contract, and if the deadline falls on a Saturday, Sunday, or legal holiday, goes to the next day. Not 5 p.m., goes all the way to 11:59. In fact, we had a deal yesterday where the attorney on the other side decided that he was going to go home and watch the Gator basketball game, which I did too, but I went a little later. And we were still waiting for the Federal Express truck to deliver closing documents so we could close. Federal Express truck got to our office at 5:30. The other office was closed, and we could still close. We're not in default because as long as you can close up to 11:59, we can close. But we closed this morning, so everything worked out. But if the seller wanted to argue that we didn't close, 5 p.m. is not the end of the day. You all know that when you're negotiating transactions. Sometimes realtors forget that when it comes to close. Everybody wants to raise Cain about something that 5 p.m. must be the end of the day. It's not. Okay? Now, then we go on to the next page on the co-op form, and this isn't in the condo documents, but this is list on 8, 9, and 10. We go through all of these forms, and I'm not going to belabor them, but as I said before, we're not getting a deed at closing in a co-op. We're not getting a lot of the stuff we normally get, but we're getting assignment of the stock ownership, and this is a laundry list of the documents that the seller will provide at closing. I don't think you need to know all of that, except you just need to know that it's different from a residential real estate of dirt, and we're going to have the seller provide all of that and make warranties with respect to the transfer of the co-op membership. The buyer then is also going to sign an agreement to be bound by and pay under the co-op documents if required by the association, new cooperative documents in the form satisfactory, and all other forms. So most of the co-ops have a specific form they want you to use to transfer the ownership of the co-op. It kind of is like, anybody here ever been involved with selling like a covered parking space at Angler's Cove or some of these other condos? They have their own little form they want you to use. This is the same thing with most co-ops have that. The good news is most co-ops are cooperative, not only existing, I shouldn't have said that, but with us and you to try to make the deal work out, okay? At least in my experience. So that works out pretty well. And this talks about who pays the expenses, and pretty much parallels the residential real estate transaction as to who pays what. Just again, make accommodation for the fact that we're selling a share of stock. Okay. Any questions about that? Okay. We've got the FERPTA. I've seen a lot of FERPTA. I'm in the ALTA chat group nationally, and somebody in there really likes to push that they're experts on FERPTA, so there's always a little something on FERPTA in there, and I giggle. But what this is, in case you didn't know, Addendum of Sales Contract, FERPTA, Buyer Residential Use Certificate. If the buyer will sign this, it doesn't. There's an exception in FERPTA. FERPTA has, as you know, we withhold 15% of the gross sale price. And just to make sure everybody understands how FERPTA works, it's not a tax, it's a withholding. And we have to send the 15% withholding to the IRS within 20 days of closing. Then the seller, who was subject to FERPTA, files an income tax return just like we do, and gets to apply the amount that's withheld to the tax liability in connection with the sale or any other income they had during that year in the United States. Okay. Some of them can get a refund, just like anybody that's working that's had more money withheld from their pay than their tax liability gets a refund at tax time. Some of them actually owe more money than the 15% if they've done very well on the property. I understand a lot of those people don't file a tax return and just give up on the 15% that went. I cannot tell them, any of them, to do that, because that would be telling them not to follow the United States tax code. But understand, their deadline is the same as your deadline, April 15th. They file this, it's almost identical tax returns, NR. Instead of a 1040, it's 1040 NR. But that they get to use that 15% that was sent to the IRS as a credit. Now, in connection with all those people, they need U.S. tax ID numbers. Those are not simple to get anymore. So as soon as you get a foreign seller, you need to put them in touch with somebody who will get them a tax ID number if they don't have one. Because as you can appreciate, we got to send that 15% to the IRS whether the seller has a tax ID number or not. And can you, with some minimal knowledge of how well the United States government works, how easy it is to match up 15% money with no tax ID number that got sent to the IRS, and now a newly acquired tax ID number person filing an income tax return asking for a refund. So as they match them up right away, right? In 5 years. So it's really great. But if the seller doesn't have a tax ID number, there's nothing in law that says we get to hold the money until the seller tells us that the seller has a tax ID number and then file it. Okay? Yes?
I understand that it's under 300,000 doesn't apply, correct? But why is there another checkbox for a million?
I don't know. It makes no sense to me either. These exceptions, the $1 million exception came up. First, FERPTA kicked around for about 10 years before it became effective. And it really generated with farmland. And that's why it kicked around forever and ever. So finally, when it became effective, it was kind of fun. This was the only exception, that if the buyer intends to use it at least 50% of the time, and this is the exception for all of these, the buyer intends to use it at least 50%, or the buyer's immediate family intends to use it at least 50% of the time it's used during each of the following 2 years, then the buyer can sign this form. Not 50% of a year, not 183 days, or whatever people believe makes them a Florida resident so they can claim homestead, but 50% of the time it's used. So if they're going to rent it for 2 months and they're going to use it for 2 months, that would satisfy the 50%. And it's the intent. It's not that they're guaranteed they're going to do that. It's the intent. Okay. Now, if they rent it annually, as soon as they close, we're pretty sure that wasn't the intent. Okay. But things can happen. But so people get nervous about that. But it's the intent. And I haven't seen the IRS prosecuting people for kind of not using it when they were supposed to use it. But this is for that $300,000 or less, no withholding at all. Okay. And I don't even understand the logic of all of these. Okay. But they exist. Then over time, apparently people said, some properties sell for more than $300,000. And I don't know why we had to have another exemption, but we did. So then we go to $1 million, and if they sign this, then it's reduced to 10% from 15. Okay? And then anything over $1 million, they can't do anything. So this just says that the buyer or a member of the buyer's immediate family intends to use it 50% of the time. So, and that a lot of people can qualify for that. I personally just bought a property, said, I need to get a rental agent. We want to rent it. We're going to rent it during season, and we're going to come down and use it in the summer. Okay, great. That's not a bad plan. Yes?
The individual who just walks away from the 15% of the
Well, you know, I can't tell how that works, but Trump seems to be really interested in immigration status these days. So I'm not sure that's going to work out being real good for some of these folks that want to come back into the country at some point. I just don't, I don't do immigration law. So I can't tell you all the ramifications of that. I don't think it's a great idea because I try to keep my commitments and, you know, if it says you're supposed to do so, you do it. No, they're not going to collect it from somebody over in, you know, Yugoslavia that sold a piece of property here and walked away and owes another 8% or whatever it is. They're not. That's not happening. But the 15% isn't going anywhere. So at least the whole concept here was if a non-U.S. person sells property, we want to at least have this money that goes up. And 15% was kind of like a rough idea of on a typical deal back at the time that the law was being passed. This will capture a substantial portion of any tax that would be due. Remember, the tax is only due on the gain. Yes.
Is there a liability on the buyer? Is that a buyer signs this?
Now, the technical liability will be if the buyer's lying and the buyer doesn't intend to use it, and the seller said, "Look, if you'll sign this, I'll sell the property to you for a lot less, you know, for less money because there's no withholding," and that's a good deal. The Germans used to be really good at that. In fact, they could figure out what the FERPTA withholding was, and they did things. I was not. They didn't ever do them in my office, but I got wind of things that were happening outside of my office sometimes. It seemed like the Germans could figure out the tax rate and do this and do that and all that. So, I mean, people can do that. I'm not picking on the Germans. I mean, the folks were pretty sharp. We had a lot of German people who that were subject to FERPTA. And that back at those days, 300,000 encompassed a lot more properties. Now, Marco, does anything sell for 300,000? Not even vacant land, right? So that exception's kind of, but back 20 years ago, 25 years ago, $300,000 would take in a completed house on the water. So there was
Buyer signs this, right?
Right.
He's not going to rent it.
No, buyer says he's not going to rent it. Buyer said that the buyer is going to occupy it at least 50% of the time that it's occupied.
Okay, and if he signs that, then the seller says that is this holding.
There's less withholding.
How is that connected?
I can't tell you that I think there's any connection, but I didn't go back and look at the history of the law, but it never has made a lot of sense to me to begin with. I don't disagree with you, but it is what it is, okay? Anybody else? Okay, but my point with this form is that it's not a buyer warranty and guarantee that these things will happen. It's just that the buyer's intent is that the buyer intends to use the property at least 50% of the time that it's occupied. And as long as the buyer intends that, then the buyer can sign this, and he's not lying, okay? And some sellers, some foreign sellers will require that. And by the way, a foreign seller does not include a green card alien that's excluded under FERPTA and some other people. So just because they're not a U.S. citizen doesn't make them subject to FERPTA, okay? Right? Okay. Addendum of sales contract, homeowner documents review. This document gives the buyer 3 days to back out of the deal. When I say back out, terminate the contract, get back their deposit. From the date that the buyer gets a copy of the Declaration of Covenants, Conditions and Restrictions, Articles of Incorporation, bylaws, rules, and regulations, and most recent year-end financial information for the homeowner association. This is not a form that is required by statute or law. It is an optional form. Realtors asked for this form because buyers were saying, you didn't give me these documents, you're hiding things, you're sneaky, you're a crook, you're defrauding me, not disclosing. I found out that I can't have a pink door and a radio antenna in my backyard, and that was my plan all along, and so therefore I'm going to file an ethics complaint against you in a lawsuit. Okay, so this, if you want to use it, is that the buyer has gotten all of those documents and has 3 days to back out of the deal. And remember, this is an addendum to the contract, so the seller's agreeing the buyer has 3 days from the day the buyer gets all this stuff to back out of the deal, right? Y'all are good with that? Yes?
But if you don't give it, the buyer can still back out saying he didn't know.
No, because there's no requirement the buyer get any of this. No requirement under the law for the buyer to get that. What there is a requirement under Chapter 720 is that the buyer be given a homeowner disclosure form which says here's what the assessments are for this particular homeowner association if you buy in here, and here's the money that you pay to the association. That's what's required, plus language in the contract that says that the buyer is entitled to that form and has 3 days to back out of the deal after the buyer gets that form, unless the buyer was given that before signing the contract, in which case then there's no time to back out. We'll get to that form in a minute. But this is not required. All these forms sounds like it is because it sounds just like a condo, but it is not required. The legislature hasn't gone there yet. Will the legislature go there someday? I wouldn't be surprised, because it seems like every time they do anything, they say, okay, we need more disclosure. Okay, we need more disclosure. Okay, we need more disclosure. And when I was first down here, the only disclosure required in the sale of a residential condominium was by a developer. And then somebody said, well, gee, resale, we better do something for that. And I was going like this, but now we're stuck with that, okay? Oh, co-ops, let's not leave them out. We put them. HOAs, people have to pay money. We better put that in now, And then the other thing that they did was, as they expanded all this stuff, and they said, gee, we're finding that HOAs are really heinous. They can be HOAs that have, and this was a few years ago, $400 annual assessment. And when an owner doesn't pay it, they get a lawyer to file a lien, and the lawyer charges $400 to file the lien, and then another $200 to close it out when you pay the $400 that you owed. That's just not right. So now we'll require them to give all these notices before they can file a lien. Hey, while we're doing that, let's add that to the Condo Act too. Okay. And I represent associations, so now I have to do all these things. People that aren't paying their bills, and finally, if they don't pay, we can file a lien. Okay. I look at that and I go, okay, but the legislature is really trying to make an effort to really protect people that they think need protection, and that is the homeowner and the condo owner that's not paying their bills deserve a lot of warnings before you file a lien. I understand that concept. I don't necessarily agree with it, but that's the way the legislature works. Do I think this will become a law someday? I'd be willing to bet on it, but I haven't heard anything that says it's going to. Okay. All right. Then we got addendum of sales contract housing for older persons. You deal with those. Seller has disclosed, buyer acknowledges property qualifies as housing for older persons. At least one person 55 years or older must occupy. Okay, a lot of your properties down here that claim they're 55 and over don't really meet the criteria. So you need to be kind of careful. This is the one that the seller signs, and you as an agent represent to somebody that is 55 or over, you might have a problem. Okay. Okay, we went through this on leases, so I'm just going to real quick say this is the same thing on sales of a lead-based paint pre-1978 property. Mostly on Marco, we're talking about the one we're going to tear down and build a new house. So still required, okay? Getting into a sales contract leased back by seller. So what we've got here is that you're making the contract, and this is a good form, you're making the contract contingent on a lease back, right? And it says here that not later than 15 days from the, not later 15 days after the effective date that the seller is going to be given from the buyer a lease, and the lease is going to have these terms in it. Who's going to pay what? Rent's going to be this. So we've kind of hit the high notes, things that people leave out, seller lease back or leasing the property. We don't address all these things. These are some of my first questions. Who's paying for the garbage? Who's paying utilities? Who's doing this? Who's doing that? So we kind of lay it out here. So if we're going to make it contingent, this is going to be, it has to be an acceptable lease. And if they do not agree on an acceptable lease, right, 5 days after receipt thereof, buyer may terminate the contract. So buyer's attorney prepares the lease, provides it to the seller. If the doesn't accept it within 5 days, then the buyer can terminate. Everybody good with that? Okay. Personal property inventory. We have the section of the contract that says other personal property, and if you're supposed to list anything, it says per inventory attached here too. I hardly ever see inventory attached here too. But if we're going to make the contract contingent on the buyer approving the inventory, then we use this, and it says the buyer's approval of inventory not 2 days after receipt, and the seller delivering not later than 5 days after the effective date, and then the buyer can terminate not later than 10 days after the effective date if the seller fails, or not later than 2 days after the buyer gets it. Okay? It's a good form. It gives some deadlines in on when the buyer can terminate and how long people have to do what they're supposed to do. Okay? Are you good with that? All right, get me to the next chunk, please. Where am I going here? Good. Yep, okay. All right, now we're on the addendum to sales contract, seller financing. All right, so just so this form is you're going to use this whenever your seller is going to be financing. Anybody seen those? I've seen a few of those in the recent market. Anybody else seeing those? Okay, some of your older people are real happy in a market to get a 6% rate of return or whatever it might be, and they view it like a CD. And if they can get 4% on a CD but 6% on seller financing, they're happy to sell and take back a note and mortgage. And this talks about the financing arrangement. The only sellers that can finance are individuals, trusts, or states. That's it. Okay, corporations, LLCs, things like that cannot do seller financing from a seller standpoint. So it says here that either the seller or buyer can terminate the contract by giving termination not later than 10 days after the effective date if the seller and or financing described herein does not comply with the Dodd-Frank Act, or if the or meets one of the exclusions set forth in 8. Seller's failure to terminate shall constitute a representation or warranty to seller that the seller either falls within one of the exclusions, and we'll get to the exclusions in a minute, but there's only exclusions that, for your purposes, other exclusions, but if you get outside of an individual or a trust, get a lawyer involved. Not later than 5 days after the effective date, buyer shall furnish such credit, financial, employment, and other information about the buyer as is reasonably required by the seller to evaluate buyer's creditworthiness. Seller shall notify buyer not later than 5 days after receipt of credit information whether the seller approves it or not. This is an important paragraph because when I see this form being used, I rarely, by the time I get it, rarely do I find that the buyer has provided any financial information to the seller. And you know why I realize that? Because the seller says to me, how do I know if the buyer is credit worthy? Now, understand that makes it awkward for me because I don't really want to go and say, well, this form that your realtor used says that the buyer has 5 days to give you all this stuff. And you have another 5 days to say whether it's acceptable or not. And those days are gone. So I kind of walk around that, but I will tell you, you need to be aware of it. Because if you're working with the seller, you need to start making an immediate demand for that if the seller wants it, and discuss this paragraph, again, my opinion, with the seller that, hey, if you want to worry about the buyer, then this is what we can get from the buyer. You can ask for the buyer to run a credit report on the buyer and give you a copy of the credit report run by the buyer. You can ask for the buyer to give you a copy of their tax return. You can ask for the buyer to give you a copy of financial statements. Give them your brokerage account. You can ask for all that stuff. Okay? It doesn't say, and all that to me would be reasonable because if I wanted to loan money to you and I wanted to see whether you're going to be able to pay me back, nothing that I just mentioned would seem unreasonable for me to determine, oh, okay, now that I've looked at all this stuff, I think you can pay me back. Now, do I think the buyer could provide that and maybe redact things like my social security number? And yeah, I think you could. I think that would be okay. But and a bank account actual number, that kind of thing, I think you could do that. But that just lets you know you have that period of time to do that, okay? Then it says, at the closing, the buyer will execute and deliver to seller a negotiable promissory note payable to seller, and we talk about the terms of the financing here. Interest rate, amortization term, balloon, and make sure you fill all that in because we get these in and sometimes there's supposed to be a balloon but it's not filled in, or maybe it's supposed to be something else, but make sure you fill all those in. And it says the buyer shall be personally liable on the note. The note allows buyer to prepay all or portion at any time except in the seller's fiscal year of closing, and that's because some sellers are looking to not recognize the income all this year when I close, but is also looking at the fact that under this arrangement, the seller pays and recognizes tax on their gain as they're paid. So since you're getting paid under a mortgage over a period of time, each year they pick up some of that gain each year. And some sellers will not want to recognize that this year, and that's one of the attractions. They're thinking they're waiting 5 years before they recognize the bulk of what they're getting because there's a balloon feature, but that doesn't require that we wait 5 years. So again, when you're thinking with your seller, if your seller wants to wait 5 years and not recognize money because in 5 years they're retiring and they'll be in a different tax bracket, and that's a good time to recognize the gain here, then you would want to put in a no prepayment allowed during 5 years. But that's something that you probably shouldn't be drafting. You should get the lawyer to draft, okay? All right, then we move on. And the note and mortgage prepared by the buyer furnished to seller not at least 15 days after the effective date of the contract and contain terms and conditions that are customary in the local market. Mortgage contains a due on sale clause, and this just says what's in the mortgage. And these are the exclusions. We've got one property, and that's the one natural person, estate, or trust, providing financing for only one property, and it can't be property that the person built. So if you've got that owner builder that's doing things, or whatever it might be, or you've got a licensed contractor and they're building a house, they can't do seller financing on that property. Okay? Any questions? Pardon me? Well, this was all part of the mortgage meltdown. Dodd-Frank changed the rules, and the rules were changed purportedly to protect buyers from predatory private lenders. And the rules really were designed to drive private lenders out of the market so that the banks and Wall Streeters would have all the financing for mortgage financing. I can tell you, if you ever look at when they pass laws, who are they really trying to help? That's how that played out. But purportedly was to help because private lenders were predatory. And mostly, didn't you all find when we did have more private lending, the interest rate was higher from a private lender than it would be for a comparable mortgage from a bank? But it was also much easier to get, and maybe the person wouldn't even be able to get a loan at the bank. So if interest rates were 6%, you get private money, it might be 8, 9, or 10. Well, in this market, is that predatory? That's a question. So, they did have some horror stories where people were borrowing money and they were paying huge money to. Well, there's just an exception because this whole thing isn't to be for commercial use. It's to be for that person that's selling a house or a trust that's selling a house. They carve out for the people selling properties was these are the one-offs. That you've got the older people down here, like I just talked about, that view this like a CD, and they're willing to do that. Or they're going to help somebody move into a house that really couldn't afford it, and they're going to do this arrangement kind of thing. So, because these, in my opinion, these don't hurt commercial lenders, okay? Because there are a lot of them, okay? All right, addendum of sales contract, short sale. Okay, we went through this, so we're good on that. Simultaneous closing, developer, right? This form, I just tell you what it does, because we're trying to buzz through these. This form is very important because when you do have developer deals, and we see that developer get, they're getting different, their contracts are harder to get around these days, but you'll get somebody that'll buy a developer product, and it's not going to come online for 2 years. So they put the deposit up, and 2 years from now, that developer product that's sold for $500,000 is now $700,000, $800,000, whatever the number might be, right? And the buyer says, it's 2 years later. My idea was I really wasn't going to close on this anyway. I was going to wait till they were building this thing, and then I'm going to sell it to somebody else and make a profit, okay? But how do they structure that, right? So I've got a contract to buy, and Charlie is going to take that and buy instead of me because Charlie wasn't as early as I was because he was still working up north. He didn't even come down until this week, and the price is now ready to go. So I sell my contract to Charlie, right? My $500,000 contract. Charlie pays me $650 because the developer wants $7, and I give Charlie one for $6. He says, yeah, it's a better deal too. And that's what the developer doesn't want, right? Developer doesn't want to compete with me while the developer is still selling product. But in case we're able to do it, what we normally have to do is that Charlie's going to give me some dough, and we're going to use Charlie's money to buy it. We're not going to use my money to buy it because I'm getting out of the deal. If you don't use this form, I can't use Charlie's money to buy the property and deed the property to him. So the way we try to structure that is I still close because I can't assign the contract. But I'm not going to use my money to close. I'm going to use Charlie's money to close, provided, and this is what this says, that I immediately deed it to Charlie. So, but if we don't have part of our contract that says, hey, we can use Charlie's money to close, provided the title's good, yada yada, all that kind of stuff, and marketable title will happen right away, and nothing. Then I can't use Charlie's money, and the whole thing falls apart. Or I use Charlie's money, and I've used it. Whoever closed the deal used it illegally because we didn't have permission to use Charlie's money. Or Charlie gets smart and he says, now that I realize you're using my money, I'm going to hold you up. I'm not paying you $650. I'm paying you $500, and that's it. You're out of the deal. Otherwise, you're not using my money, and I get my dough back because you can't close and you can't convey to me. So, you have a problem. So we use this, and that allows us to use Charlie's money instead of my money, which is what the plan was all along, right? Now we do that, okay? Well, I think that was the plan, okay? And I did a form like that when we were originally doing some stuff in Lely, because my client was taking down lots to build property and wanted to use the buyer's money to take down the lot and do all that stuff. We couldn't do it under a sales contract without an addendum, okay? So this is a good form if you're doing that. So please be sure that you understand how that works. Yes? Okay, just so you know that's there. Addendum of sales contract, VA, FHA financing. The key on FHA is that it has to appraise, so we put in here the appraisal amount. It has to appraise at that. There's not too much trouble with VA and FHA financing anymore. It used to be more difficult with limitations. But I just want to let you know that if we do have a VA or FHA financing, we need to attach this. So if they check the box in the contract that that's the financing, we need to attach this addendum. You got people up north that are looking at the nice pictures you sent them, looking online, but they want to fly down here this weekend and look at it to make sure it looks like it's supposed to. And I have had people come down and go, it doesn't look at all like the pictures. It's horrible. You know, of course, I don't get the good ones. I don't get them come down and say, oh, it's even better than the pictures, right? No, I get the ones because I'm a lawyer. This is horrible. You know, this thing doesn't look at all like it did. I don't know where they took these pictures. It's not even the same unit. So anyway, this gives the buyer up to a period of, you know, whatever, and 10 days if left blank for the buyer to come in and make a personal inspection. I just used coming down this weekend because I see that even though they trust you and they think your pictures are accurate and all that, there are still people that will want to come down here and look at it. So once again, instead of talking to those people and saying, okay, we'll wait till you come down, and they go, we're not coming down unless we know we have a deal, and then we're just going to come down and make sure it's okay. This is how you make the deal, okay? All right. Then the sales contract as is, due diligence. So this form can turn the regular sales contract into an as is with the due diligence right to inspect. All it does is it just takes out the inspection portion and puts in the, hey, buyer has X number of days within which to inspect and decide whether they're going to close or not. Remember, whatever that time frame is, just as with the as-is sales contract, both Farbar and the neighbor, whatever that time frame, they don't get an extra 5 days like they do under the inspection provision. That's the deadline. They have to terminate by that deadline. And that's a time trap for you guys because I've seen realtors working with other realtors and they're negotiating and they're working on some problem and everything's so close and the seller's agreeable and everything and it looks beautiful, and then that day comes and goes, and then the day after that the seller says, go pound salt, I'm not doing anything. Okay? And I can't tell you that that's a setup by the seller, but it could be. And even if it's not, I mean, now I've got my realtor working with the buyer and they've let this happen because they think that everything in good faith was the way it should be and they weren't worried about that deadline. So I tell you that because it's a real life horror story and it breaks my heart to see that happen. Yeah.
Why would they use this addendum with the regular contract and not just write an as-is contract?
Because while you're negotiating the deal, somebody says, okay, well, I'll tell you what then. Instead of doing all itself, I'm not going to do any repairs. I'm just not signing this because I see that you have 15 days to inspect and then whatever it is you can ask me. I don't even want to do that. But what I will do is I'll give you X amount of days to check it out and decide if you're going to buy it or not. Okay? I don't think this happens very often, but that's why it's there. And originally the genesis of this was we did not have an as-is, a right to inspect contract, and Farbar did. And rather than write a whole new contract while we were doing short sales especially, is we put this together so we could have sort of one and wouldn't have to use the Farbar contract. Okay. Yes, another one of my favorite forms. Amendment sales contracts. The only difference between this and the addendum is it has a different name and it gives you the same opportunity to make a mistake, right? So again, highly recommend we don't use that form. Amendment to sales contract, closing date change. We see this a lot, right? We're going to change the closing date. People say, well, do I have to do anything? Yeah, it's a really good idea. Remember, what's the only thing in the neighbor sales contract that clearly says time is of the essence? Okay, so we're going to change the closing date. Let's do it, right? Easy form. Look how simple that is, okay? Right? Amendment to sales contract extensions, closing date extended, financing contingency extended. So look, what this is a kind of one size fits all for all these different things. Financing contingency extended. People say that to me all the time. Well, what happens when the finance contingency comes? You know, what? I go, well, you all talk, right? You can talk to the other agent, try to work things out. They go, we should do that? We're going to talk to each other? Okay. But there's a good example here. You want to change some of this stuff? Fine. And we try to do this before the day that the deadline happens, right? Inspection period is extended. Due diligence period is extended in the as-is. Title examination is extended. Title clearance period is extended. Remember, the title clearance period, if there's a title defect, seller has 30 days to cure. Okay? Under the Farbar contract, the buyer can require the seller to take another 120 days and cure it. Under neighbor, they can't. But if we're going to extend it, we do that here, okay? Everybody good with that? Did y'all know this form existed? Ah, y'all are good. What are you doing here? You should send somebody else. All right, assignment of sales contract. This is an important form I want you guys to use. What we have with the assignment of sales contract, people say is, oh, I think we'll take title like this. And I go, well, all those people aren't on the contract. So we have to assign the contract. And when I represent the seller, I have to look at whoever's working for the buyer and I go, No, that's not how this works. You have to assign this to them. It's okay because the neighbor contract is freely assignable, but we still have to go through that little step to say that now they really are buyers, so they get to be on the deed. How's that working out for you? Oh, really? I go, yeah. Now, the beauty of this is, look whose signatures are required. Okay, say it with me. Buyer, assignor, buyer, assignor. How about down here? Assignee. Assignee. You see the seller's name on there? Okay, so why would we do an amendment to contract to change the buyer? Somebody raise their hand because people do it. We wouldn't, would we? Not with a neighbor contract because it's freely assignable. There's no reason for the seller to have to agree. So why do we want to go ask the seller and make a big deal out of it when all we have to do is have the buyer assign it and have the assignee say, okie dokie, it's good, right? Everybody good with that? So we don't have to go and amend the contract to add a buyer. Now with FAR you might, if they check the box that says it's not assignable, okay, it's a different animal, but not with neighbor. And we like that. I like that a lot. So use this form. Financing contingency, buyer termination notice. Remember we talked about that? The buyer is going to terminate the contract because, right? Now, the reason this can be used, remember, the buyer can only terminate the contract if the buyer gets a denial letter from the bank, right? I've seen those, and they're pretty rare, but I've seen them. Usually what we get is, oh, the loan officer says you're not getting the loan, you know, your credit's horrible. Never seen anybody who was this poor in my life. What are you doing? Reminds me of the guy that rode the bicycle around. He was putting offers on properties. Realtors were falling all over themselves, taking this guy to dinner and stuff. Then they couldn't find him later. He was riding a bicycle, though. So he must have had money. Anyway, this is the buyer's termination, but only if that happens, right? Other than that, I think that it's courteous that when your buyer has been told by the lender that ain't happening, that you talk to the seller and say, hey, we've been told it ain't happening. You want to terminate now so you can put it back on the market, or do you want to wait until closing so my buyer can come in and say it ain't happening? It's up to you. Now, most sellers say, okay, let's put it back on the market. Some of them get very unhappy about that. But, you know, if I'm a listing agent and I've got somebody and it's March and I've got 30 days before closing, I would much prefer to have that property back on the market in March than I would wait till the end of April and then try to put it on in May and after everybody's gone back up north and sell the property. So this is what, when the buyer did get that denial, then you can use this form, okay? Okay, financing contingency extension, right? So you're going to extend it till whenever, certain date. Financing seller termination. So remember, if the buyer doesn't waive the financing contingency under the neighbor contract by the deadline, then the seller can terminate anytime up until the buyer waives. Yes? We're good with that? Here's the form to do that with. Yes, and it says that the escrow deposit goes back to the buyer because the buyer didn't waive, therefore the seller now has the right to terminate. I always tell our buyers that when they say, you know, what's the risk if I don't waive the financing contingency? The risk is the seller can terminate the contract. Okay, is that something that's really scary to you and you can close cash and go ahead and waive? But that's a discussion that I don't think you guys should have. I think that's a discussion for the attorney because we make sure that we dot our I's, cross our T's, and I'm not going to get sued for the buyer waiving that when the buyer loses the deposit. And I'm just a little fearful that you guys might not do quite as good a job with that. So, and they're going to blame you. If they lose a deposit, it sure isn't going to be their fault. Okay. Financing contingency waiver. Okay. I just don't like this form because I don't think realtors should be doing that. I think it's just, I think the liability is too great. I mean, it's good for me. It's liable for me too, but I feel like we can take care of it. Flood insurance disclosure, you know, that's required now by statute in Florida. So due to prior to entering the sales contract, buyers are advised to consult with one or more insurance underwriters about flood insurance. Now remember, 10 years ago, I think our contract said that the buyer had 10 days after the effective date to check on insurance, and if it turned out that it was going to be too expensive, they could terminate the contract. I don't know why realtors didn't like that, but we took that out. Now we're saying, hey, you better check out insurance before you make an offer, okay? So it's in the contract. Flood disclosure, this is required by statute, okay? Seller has or has not filed a claim with an insurance provider relating to flood damage on the property. Is that deal you had that fell through? That would have had this involved with it, right? They had a lot of flood damage out there. You should see those units all look really nice now. Seller has or has not received federal assistance for flood damage. Flooding means general or temporary condition of partial or complete inundation of water caused by basically flooding. Okay, so this is required disclosure. Okay, it's not an addendum, not an amendment. We need the next chunk. So this has to be part of your transaction. Okay, we're in the home stretch. Now this is a contract. I hate to use this because I really don't want your deals to ever be terminated, but termination of sale contract buyer notice. So what the committee did was try to come up with a list of every reason that the buyer could terminate the contract and put it on a form. Okay. So we try to make life easy. So you can go to, does this apply? No. Does this apply? No. Okay. So, and this form was fixed because it didn't have all the reasons on it. I think it's pretty good now. But if you look at it and you have a deal and you find out that your reason is not on there, if you let me know, I'll make sure it gets on there next time we revise the forms. But this goes through all the different ones: as is, appraisal, backup, homeowner document review, lease back by seller. We go through everything. And this is a good form because it goes through everything: sales contract, seller refusal or counter of buyer's election for remedial action. Remember, that's the buyer found some defects and asked for them. Remember, the seller has 10 days to say whether the seller would do it or not. Okay, and we get down and the buyer signs that. The seller doesn't have to sign that because all of those, the buyer has the unilateral right to terminate. Okay, now, anybody ever tried to do this and find out that whoever's holding the deposit won't let it go? Okay, so I want to warn you, I don't find any fault with that because I hold lots of deposits, okay? Because I don't know what deal what the buyer and seller have done outside of the buyer signing this form. So if I release the money because the buyer said, okay, I'm terminating, I don't know that they have some other agreement, some other in writing, where they waived, whatever, you know what I'm saying? So that's why your people holding deposit money won't release it unless the seller agrees. So don't think that this is an automatic, we're going to get the money back. And I'm not telling you that because I hold it. Anybody that's holding the money, I tell my client, when I'm the buyer, look, I'm your attorney, but as an escrow agent, my duty is to protect the deposit. Under all circumstances, I am not your best friend, will not give you back the money just because you want it. So that's, and I think anybody that's holding the money is going to do that. So this form, I'd like to tell you, works. I don't think it does very well because the person holding the deposit is going to be very reluctant to release it. Now, there are cases that I've had where it's so clear to me that there's no problem, I'll release the money. But that's not the majority of the time. Yes?
So is the seller's agent allowed to put something back actively before they have documentation signed by the buyer?
Well, that's really a better question for your broker. But as far as contract, the question that I get more often is, and people are under the impression that because we're arguing about who gets the deposit, that the property can't be put on the market. And I go, no, we're arguing over the deposit, not over the property. The property can be put back on the market. Now we're going to argue about the deposit, whether or not the buyer or the seller gets it. That's not a title issue. That's a deposit argument, okay? So that's important because that will help you get things done. Now, the downside to that is now the seller may be less inclined to reach some settlement arrangement. And usually everybody's better off being done with it and moving ahead in some fashion rather than hiring lawyers and going to court, except for the lawyers. Okay? I do make more money litigating than when everybody gets along. But that doesn't stop me from trying to get them to get along because it has to make financial sense for me, for my client, to spend lots of money on a lawsuit. And if you're talking like a $40,000 deposit or a $50,000 deposit, that's just not a good lawsuit for anybody to be in. Too little money, too much lawyer fees. Okay, but that's how that plays out. So we are arguing about the deposit, not about the title, and you can put it back on the market. Yes?
Is there not another form that goes with that says termination of contract and release the deposit that has a buyer and a seller on it?
Doesn't go with this, but it is another form we're going to get to in just a second. You're right. See, none of your deals ever terminate, but these other people that their deals terminate, they try to use that form. Okay. Okay, anybody else? All right. Termination sales contract, seller notice. So this is kind of the other shoe of one party gets to terminate for some reason. So we've got all these things. Now here, if the seller terminates, it's a lot easier for me to give the money back to the buyer than it is when the buyer's terminating, right? So if I see this, it doesn't stop me from giving the buyer back money, and it doesn't necessarily stop the buyer from suing the seller for damages or specific performance if the buyer says the seller didn't have a right to do that. Okay, so we still may be able to release the deposit. And sometimes I might tell the buyer, look, might be better off just leaving the deposit here so there's nobody that can claim that you weren't trying to close because you got your money back. Okay, but this lets the seller terminate the contract based on the seller financing, review by advisor. These are the criteria that we have for the seller being able to terminate. Okay. This is purchase price escalation. Y'all may have been using this while the market was red hot. And it says that if the seller receives one or more competing offers from a bona fide arm's length third-party buyer with terms acceptable to seller, which have a purchase price equal to or greater than the purchase price stated in this offer, then the purchase price in this offer shall automatically increase by whatever the dollar value is, in excess of the highest purchase price in such competing offers, okay, not to exceed a purchase price of, and then there's a blank with a dollar sign, okay. So the rest of this form I just kind of just skim through. So this says that if you're in a hot market, and you know, y'all enjoyed that where they said, okay, we're looking at all the offers on Friday. So submit all offers, you know. We'll look at them and we'll let you know if you're a successful offeror, right? So this was in response to that. People said, well, gee, I really want this and I'll offer more money. And I kind of like looked at that and I go, well, you're just telling them what your top dollar is right here. Why don't you just make an offer and try to buy it for that? They didn't like that because they're trying to buy it for something smaller. So this would work for that. And if we got a bunch of them in there, it becomes a bit of a mess because we keep going. And whoever's got the highest number here, that's the winner insofar as who's got the highest offer. Now then it's up to the seller whether they like that deal or another deal, or was that contingent of financing or not, or whatever it might be. I mean, you all know how that works, but that's what this form is for. Yes?
The seller and the highest offer with the escalation is less than that dollar amount. The seller doesn't accept any of it. And if somebody says I'll pay $3 million, I'll escalate but not to exceed $3 million. All the contracts are in the high twos.
Well, the seller doesn't have to accept any of them. This just allows that. But this form was used when we had multiple offers, and we were pretty sure we were going to have multiple offers. So rather than just say, okay, here's my highest and best offer, we said, well, we're going to offer 2.8, but I'll go to $3 million, and I'll go up by $5,000 over the, you know, next offer, whatever it might be, but I'm not going to go above this number. So the seller doesn't have to accept any of those. Well, I can't speak to that. I'm not a licensed realtor. But those are the kinds of things you discuss with your seller, okay? All right, so we know what that form is for. Addendum to sales contract, insurance unavailability due to extreme weather conditions. We kind of have this covered in the contract, okay? But it's not completely covered because it just says if it's a cash deal, remember that we have a provision in the contract that says if we've got extreme weather conditions and it precludes closing because a service required for closing is not available, then we put it off and, you know, go through all that. But, oops, excuse me. This form would be, so the lender won't close because you don't have insurance, so we can't close because we don't have financing. So for financing contingency, we can get out anyway. But if we don't have insurance because we've got a hurricane in the cone and we can't get the windstorm coverage, then we can defer closing until it does become available, not more than 5 days after insurance coverage becomes available. And if it's not available for 30 continuous days, then either party can terminate the contract, okay? So I don't see this very often because people tend to like just what's in the contract, but this is specifically an insurance clause. And this might be something you want to use during the summer months, especially, you know, July, August, September, October, when storms tend to brew. It might work well for you because, you know, once it gets in that cone, and then the next hurricane or storm gets in this cone, and then another one gets the cone. You know, so there's a period of, you know, a month we can't get any windstorm coverage for anything. Now, keep in mind, if you've taken your customer to the insurance agent, and your insurance has issued a commitment to insure, then whether the storm goes in the cone or not, they can get a policy. So it really behooves you to get those folks in touch. And I always tell people, for all this stuff, they should use somebody that's down here that deals with all this, not go home and talk to their, you know, local insurance guy or gal and try to make everything work. It just doesn't work that way. So this is a good opportunity to take them to the insurance people or recommend somebody or some insurance companies, and they go there before they go back up north, okay? Okay, addendum to sales contract, seller concessions. So here it is, credit amount of blank towards closing costs and prepaid, credit amount of either flat fee or percentage toward buyer's broker's compensation, other compensation paid to a real estate broker, or any broker commission not set by law that's required by the settlement agreement, the NR settlement agreement. So look at this form right here. I want to point out this is a seller concession. This means that the closing statement will show that the seller is giving the buyer some kind of a concession. We have used this, didn't have this form before, but we have used this type of thing when the seller was giving a credit for the busted air conditioner or, the faulty whatever it might be. And you still can use that. But this now can also be used because, as you know, seller concessions can be in MLS. And if a seller is going to give a concession to a buyer, we put this paragraph in the hope, right here, in the hope that if you fill this in and use this, that it will actually be used to pay the broker compensation to the selling brokerage, right? Because there's no legal obligation that a seller giving a buyer a concession, that concession be used to pay compensation to a buyer broker. Everybody good with that, right? If you're entitled to compensation, it's because you have a buyer-broker agreement, right? And this, if it's going to be used to pay, this can be more than what's in your buyer-broker agreement because your limit is not necessarily the limit of what the seller can give a concession to a buyer, right? So if you have a limit in your buyer-broker, that's the maximum you can get paid. And if the contract negotiates a bigger credit here, then the seller is still going to give that credit. Whether it goes to you or not is dependent on what your agreement is with your buyer. Everybody good with that? Okay, so this doesn't run afoul of the settlement agreement, even if the numbers don't match. And of course, if this is less, that doesn't reduce the amount that your buyer is supposed to pay you. You have an agreement with your buyer, whatever that is what your buyer is supposed to pay you. Now, I also want to point out that seller concessions, and I see a lot of confusion, not probably with you guys, but this is something I want you to talk to your friends and family that are in the real estate business. I see a lot of confusion between the buyer brokerage arrangement and co-broke and compensation from a listing broker to a selling broker and a concession from a buyer. A concession from a seller to a buyer is not the same thing as an agreement in a listing contract for the listing broker to pay something to a selling broker. And I see this form used in contracts prepared by realtors who are saying, okay, we want some money, we want the seller to pay the buyer, broker, X amount of money. And we're going to do that for this form's purpose through a credit, a concession, right? We're going to give a concession of whatever the amount is going to be. We'll say the seller is going to pay that to the buyer, and that's going to pay the buyer's brokerage fee that the buyer and the broker representing the buyer or working with the buyer have signed, right? Everybody understand what I'm saying? However, if the seller has a listing contract that says, I'm going to pay the listing brokerage some money, and that contract says, and the listing broker is going to pay part of that money to the selling broker. Now the seller is paying a concession, which I find people goofing this up, happens to be identical to what the listing brokerage contract says that the listing broker is going to pay to the buying broker. Everybody understand what I'm saying? Double dip. Now the seller is obligated to pay whatever they've agreed to pay the listing broker, of which they've agreed the listing broker is going to pay something to the selling broker. And the seller has now signed a contract that says, oh, I'm also going to pay, usually, an amount equal to what my listing agreement says the listing broker is going to pay to the selling broker as a concession to the buyer. Now, if you do that, and your seller wakes up, because at closing, there will be two charges on the closing statement. One will be to the seller, a fee to the listing broker from which the listing broker is supposed to pay something to the selling broker. And then right below that will be a concession to the buyer, which normally would be some portion of what that fee above it is. And the seller will then say, what the heck is that? Because you guys helped do a contract like that. So I see this. I had a broker in Fort Pierce argue with me that this was okay and it's the same money. And I had to say no. And I was the executor of an estate. And I said, no, we're not signing that because I'm not going to pay twice the same money. And then the agent elevated that to their broker who continued to argue with me. Okay? So this is particularly painful for me because it is mathematically impossible to not be double dipping, okay? So, now does this get worked out? Remember the 99% rule? it probably gets worked out because everybody realizes, oops, but if it doesn't, whose butt is in the frying pan? Not mine, yours, okay? All right. Then the sales contract compensation, okay? I just had my story with you about the other form, very similar here. Listing broker agrees to pay the contract's contingent, okay, remember, because this is addendum, so now the contract's going to be, including these clauses, the listing broker agreeing to pay the buyer's broker at closing compensation of this, or seller agreeing to pay buyer's broker. This is the one I actually had the argument with the broker over in Fort Pierce about, was this right here. It's the same thing, okay, or other. So remember, if you've got an arrangement with the listing broker that the listing broker is paying, then this is not a problem. But why do you want to end up making it part of the sales contract? I mean, that's kind of mucking things up that doesn't have to be mucked up, right? You've already got an agreement with the listing broker that the selling broker is going to get some money, and that's what you're getting, and you're happy with that. And that doesn't exceed the amount in your buyer brokerage agreement, so you're good to go, okay? So if seller does not deliver a copy of a binding agreement on the terms set forth above prior to expiration of the delivery period, buyer may terminate the contract. So this we see when buyers say, yeah, I have a deal with you, I'm going to pay you, you're going to work with me, but we're going to make a deal that I'm really not going to pay that, we're going to get the seller to actually pay that some way. So this guarantees that's going to happen. Okay, addendum sales contract, allergenic molds. As you know, the neighbor sales contract defines a defective mold condition as being toxic or pathogenic and specifically excludes Penicillium aspergillus as a toxic or pathogenic mold. So if you've got a customer who is particularly sensitive to mold or anything in the air, this is a form that says if the mold inside the unit exceeds the mold outside the unit, then it's a defective condition, okay? So this expands the type of mold that would be a defective condition under the contract. And then you go back to your 15 days and all that. Everybody good with that? Okay, so you need to know your buyer. I always think of kids with asthma and they've got breathing problems. I know old people have breathing problems too, but I happen to have a soft spot in my heart for kids, as y'all know. So I think about a family coming in with a child that's got a breathing issue, and now there's any mold at all is a real problem for that person. And we have a sales contract that says it has to be toxic or pathogenic, not just affects breathing. So this expands that. Everybody good with that? Okay. And it says right here, not to be used with the as-is sales contract, because remember, as is, they have the right to inspect, do whatever they want, and they have X number of days that they can terminate, okay? Believe it or not, we're all done. Any questions? And I did not have your form, because it wasn't an amendment. I don't know how the other one got in there. I accidentally put that one in. I went through all these forms and, was checking them off to send them over to Caroline, and you can appreciate that was tedious, and I probably should put that one in there because I liked it for them. Any other questions about anything? It's your last opportunity. All right, well, everybody, please wake up now and go out there and sell some property.